The 11th Circuit read this court's precedents to teach that the ultimate inquiry is whether a work is attributable to the constructive authorship of the people, which is to say whether it was created by an agent of the people in the direct exercise of sovereign authority. Statutes and judicial opinions are the most obvious examples of what falls within the ambit of the rule that law is in the public domain. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, our final story today is this Georgia versus public.resource.org case, but this is the Supreme Court of the United States. We covered this a little bit, I think it was last year, where Georgia is trying to say its laws are copyrighted and you can't reproduce, in other words, make a copy for your own purposes or for other, but you can't republish in violation of copyright law their laws. And this would normally be a moot point because laws are not copyrightable. But we are talking about the annotated version of Georgia's law, which is where a company like LexisNexis or Westlaw, or there are others now, they write a summary of the law in addition to, like, being next to, like, so you have the actual black letter law, and then next to it is this annotated, highlighted, like they'll have citations, they'll have stories, they'll have suggestions, they'll have guidance there. And all of that is very much not the black letter law. So wouldn't you just copy the black letter law and leave the annotations out of it? Well, Georgia has made the annotations part of their official law.
Ta-da!
Ta-da! So Georgia makes it part of the official law and then says they control the whole thing and that you can't reproduce the whole thing. You might be able to reproduce the black letter law. I think their concern is mostly over the annotations, and especially because the annotations themselves come from a for-profit company, Lexis or Westlaw. I think this one's a Westlaw one.
Yep.
And so if they are publishing this to the whole world, they're probably in violation of some kind of agreement with Westlaw as well.
Yep.
So Georgia's motivated. But Georgia's wrong.
Georgia's wrong.
Georgia is completely wrong. In my humble opinion, we'll find out if my professional opinion is correct. The Supreme Court is allegedly going to hear this. This is a brief in opposition to a writ for certiorari, I believe. And this is coming from publicresource.org, the person who put the law on their website in alleged violation. Public Resource is a non-profit corporation, no parent corporation, nothing to declare with regard to stock ownership. They say the petition should be granted. We'll see if that's a typo or not. Maybe they do mean granted. There is no circuit conflict. I would think not granted then. Petitioners argue on the merits. Petitioners' arguments on the merits are not a basis to grant review. So
is there a typo?
I think it's a typo. I think that's a massive typo. The petition should not be granted, is I think what they're saying.
Yeah, that's a pretty bad typo, man. Wow.
Especially when you send these out. We talked about this a little bit. When you send these out for copying, this is a special size paper, a special kind of paper, and a special printer. They want thousands of dollars to print 23 copies of these things. I think is it 23? I think it's 23 copies.
23 sounds right.
Let's pay that much money to.
Yeah, you're not going to fix a typo.
For one word.
Yeah. The question presented is whether Georgia's only official code is an edict of the government that cannot be copyrighted because the law belongs to the people. Our copyright system's twin goals are to promote creation of useful works and their dissemination to a wide audience. But the courts have long ruled that governments need no incentive to create the law.
Yeah.
In issuing edicts of the government, officials act as agents of the people in whose name the edicts are issued. Here, the state of Georgia decided that its only official code should be annotated. The state itself oversaw the preparation of the work, even though it farmed out to an experienced code publisher the labor of organizing the statutes and drafting the annotations. The state registered the copyright in the annotations in its own name, compensating the publisher only by giving it an exclusive license for a limited term. If this case rose in another circuit, those courts analyzing the undisputed facts text would have arrived at the same result that the 11th Circuit did. But although there is no square circuit split, there might as well be. There is no doubt that lower courts have struggled with applying the edicts of government doctrine in gray areas. That confusion and perceived inconsistency among the lower courts has made it difficult for governments, publishers, the public, and even the U.S. Copyright Office to know their rights and obligations. And that confusion will only get worse as advancing technology speeds the distribution of government edicts online.
So they do want to grant the petition. I thought this was an opposition.
Yeah, this is weird. It says opposition. Let's continue. Respondent is a non-profit organization with the mission of improving public access to government records and primary legal materials. In 2013, Public Resource purchased all the current volumes of the official Georgia Code annotated, scanned them, and uploaded them to its website to be freely available to the public. In July 2015, petitioners sued Public Resource in the U.S. District Court for the Northern District of Georgia for infringing Georgia's copyright in the annotations. The district court granted petitioners' motion for partial summary judgment and denied Public Resource's motion for partial summary judgment. The court determined that because the annotations formally lack the force of law, they are not public domain. It also rejected both Public Resource's challenges to the validity of Georgia's copyright and its fair use defense. The court entered a permanent injunction against Public Resource. The 11th Circuit reversed, holding that no valid copyright interest can be asserted in any part of the OCGA. At the outset, the court observed that answering this question means confronting profound and difficult issues about the nature of law in our society and the rights of citizens to have unfettered access to their legal edicts that govern their lives. The OCGA's annotations go well beyond summaries of judicial opinions. They include section titles, statutory history, Georgia Code Revision Commission guidance, summaries of judicial histories, and more. These materials are not exactly a state's statutory text, which is clearly not copyrightable, or commentaries created by a private publisher, generally copyrightable. Therefore, the Court of Appeals determined that it must drill down on the core attributes that would determine whether the annotations are an exercise of foreign power. The court identified 3 hallmarks that would determine whether the entire official code, which merges statutes and annotations, should be treated as the sovereign expression of the people by their legislature, the identity of the public officials who created the work, the authoritativeness of the work, and the process by which the work was created. The 11th Circuit read this court's precedents to teach that the ultimate inquiry is whether a work is attributable to the constructive authorship of the people, which is to say whether it was created by an agent of the people in the direct exercise of sovereign authority. Statutes and judicial opinions are the most obvious examples of what falls within the ambit of the rule that law is in the public domain. But that does not mean that works that carry the clear force of law are the only works that may be subject to the rule. Rather, there is a zone of indeterminacy at the frontier between edicts that carry the force of law and those that do not. Identifying the ultimate inquiry is still difficult when a work in question does not fall neatly into a category like statutes or judicial opinions, but it does point a court toward a way to structure its analysis. Put simply, there are certain things that make the law what it is. Because the OCGA's annotations are neither obviously within the ambit of the edicts of government doctrine as statutes and judicial opinions are, nor obviously outside it, the court analyzed the OCGA's annotations using the 3 critical markers it had identified. Let's see if we can cover them quickly here. First, the Court of Appeals considered it important that the Georgia General Assembly is the driving force behind the annotations creation. The Commission also directly supervises and controls Lexis's preparation. Okay, I'm just going to skip ahead a little bit. Turning to the second critical factor, authoritativeness, the panel reasoned that while the annotations do not carry the force of law, they are nevertheless authoritative. Specifically, the General Assembly merged the annotations with the statutory text into a single unified edict stamped with the state's imprimatur and created and embraced the same government body that wrote the statutory text. The legislature did not have to merge the annotations with the statutes in order to create the OCGA and then stamp the completed work with the state's imprimatur, but it chose to do so. Finally, the panel considered its third marker, the process by which the annotations were created. They were not created by the same process as the public domain statutory provisions, but the processes are very closely related. The former are published as a collection of session laws, etc. The annotations and the commission that prepared them were adopted by the General Assembly as an integral part of the official code. The General Assembly did so through an act passed by both houses and signed into law by the governor. Bicameralism and presentment are the essential hallmarks of legislative process. The Court of Appeals concluded that all three critical markers show that the OCGA's annotations and the OCGA itself are a work of the legislature as an exercise of its sovereign power. To advance the interests and affect the will of the people, their agents in the General Assembly have chosen to create an official exposition on the meaning of the laws of Georgia. As a result, the OCGA is intrinsically public domain material belonging to the people, and as such, must be free for publication by all. The 11th Circuit reversed the district court's judgment, vacated the order, and remanded for further proceedings. So let's see if we can somewhat quickly summarize or figure out what their reasoning is for asking for the writ to be granted, the writ of certiorari that would get this into the Supreme Court. Despite the absence of a circuit conflict and the correctness of the 11th Circuit's decision, this court's review is warranted because under this court's existing precedent, the government edicts doctrine is difficult to apply when a work does not fall neatly into a category like statutes or judicial opinions already held out to be edicts. As a result, the case law is confusing and outcomes are difficult to predict. And they're going to go into that a little bit. So I'm going to skip and we'll see what their next substantive argument. There is no circuit conflict, so they're going to go into an analysis of whether courts around the country are conflicted, and we're going to skip ahead as well. This is very long, so I wanted to skim this. This is just one party's arguments as well. Petitioner's arguments on the merits are not a basis to grant review. The decision below is consistent with this court's precedent, so now they're going to start arguing against the other side. The opinion below, for all the reasons, this is just a longer version of what we just read. The ruling below is grounded in due process and respect for the rule of law, etc. So I
don't understand why that point, what is it, 3A, where it says this, or just 3, where it says it's the merits is not a reason to grant. It's like, we want this to be granted, right? Why are we bringing to the court's attention
this one?
Yeah, that doesn't make any sense.
Petitioner's arguments
on the merits are not a basis to grant.
So well, I get it. It means that even their best arguments don't reach a level of controversy that warrants review.
That might be true.
The 11th Circuit's decision should be upheld, I guess is what they're saying.
No, I'm down with that. But if your ultimate frame is we want you to grant cert, even if you think like the merits are right, which they obviously do, it's like, why bring that to the court's attention now? You want them to grant cert. You don't then say, here's reasons you shouldn't grant cert, like the merits.
Yeah,
that doesn't make any sense.
Yeah, it's weirdly written. I get what it's saying though, but if I was a judge, I would be slightly annoyed that they didn't quite understand.
It seems misplaced here.
What perspective they should be writing to me.
Yeah, it's misplaced in my view.
Either way, let us know what you think about that. We will find out whether the court grants certiorari, and then we'll be eagerly awaiting the court's opinion if it does.
I predict against.
I predict against as well. I don't think they'll grant certiorari. There is an in-between. The court can either not grant certiorari or grant and then immediately issue an opinion instead of waiting.
Oh, I mean, yeah, they could do that, but they're not going to here.
Once in a while, we've gotten like a one-pager that says we're not granting this or we are granting this, but just enough to say that we agree.
You'll see a GVR sometimes where it's like, oh, we're going to grant, vacate, remand, but there's nothing to vacate because they would be agreeing with it. So that doesn't make sense. And they're not going to do a summary.
The Supreme Court does not grant certiorari to then say we agree.
I haven't seen a true summary affirmance in like 30 years.
Okay, but it could be done. It's within their power to do so. Okay, so that's that. And I mean, I don't. If I'm missing some interesting part of this that you would like to hear more about, definitely let me know. But it seems pretty freaking clear to me the law can't be copyright controlled. maybe on some level you could say that Georgia owns something, but it would have to be only ways that didn't touch the public's interest in the law. Maybe you're not allowed to sell novelty copies of the Georgia statutes annotated. That doesn't even really work in my head. It's their official law, so it's public domain, so you can do whatever the hell you want with it.
Yeah, there's no reason for the Supreme Court to grant cert here.
Yeah, and there's no reason to grant cert because the public resource people are right.
Yeah.
And they've won. Yeah. And they should stay won.
Yeah, and Georgia should give up. But since that's not going to happen...
Georgia. So thank you very much for joining us. That is our show. I am Leonard French, your favorite copyright attorney, and this is Kurt Mueller, your favorite patent attorney. We are a community-supported legal education show called Lawful Masses, and we are supported by your monthly pledges on patreon.com/ljfrench and sponsors.org/u/lawfulmasses and twitch.tv/lawfulmasses, and this YouTube channel, of course. Thank you very much to our May 2019 supporters at the $50 level. Thank you to John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, allquixotic, and Aspernari. Thank you very much for your support at the $50 level. And all of the $5 plus supporters are on the LED panel above my head here and will be in the description of the videos that drop. So everyone have a great spring week here. We'll answer your questions here before we take the stream out, but I'm going to say thank you for joining us and have a great week.
Yes.
Bye.